Right. Well, thank you everyone for making the time to listen to me and Matt speak to you. I'm Jonathan. I'll be speaking to you a little bit later about the 1975 Act. And before then, you'll hear from Matthew Mills, who you should also see on screen. He's going to talk about claims for an account. Without further delay, I'll hand over to Matt.
Thank you very much. Let me share my screen. Good morning, everyone. I'm Matt Mills, and I'm here to talk to you about the duty to account. Now, I know what you're thinking. What could possibly be more exciting than talking about accounts on a drizzly Thursday morning? But actually, as uninviting as the topic may sound, it's really important. As Mr. Justice Lewison put it in the famous ultra-frame case, the taking of an account is the means by which a beneficiary requires a trustee to justify his stewardship of trust property. And for this reason, for a long time, the duty to account has been called the first duty of trustees and executors. But still, even though this duty can be traced back over 700 years, parties are still arguing over its precise scope. So what I hope to do in today's webinar is to take you through the key principles and summarize what that disputed law might be. In particular, I'll cover three issues. Firstly, what the duty to account actually is. Secondly, what a good account should contain. And thirdly, what a beneficiary can do if their trustee or personal representative is refusing to provide an account. So without further ado, let's get stuck into that first topic. The crux of the duty to account is actually pretty simple. The duty is simply to keep clear and distinct accounts of the property which he himself is bound to administer. Now, historically, courts have said that beneficiaries had to pay the trustees reasonable costs of producing an account. But in my view, in the modern era, it's doubtful that trustees can still insist on this. Everything's stored electronically, whether on the cloud or on a computer, and it can be emailed to the beneficiary with a press of a button. But that still leaves two questions outstanding. When does the duty arise, and to whom is the duty owed? That's what I'll cover in my next couple of slides. The short answer is that the duty to account pretty much always applies. The famous phrase is that the trustee or personal representative's duty is to be constantly ready with their accounts. Now, that doesn't mean that trustees need to produce fresh accounts every single day and carry them around in their back pocket. Instead, what it means is that trustees must be able to produce accounts within a reasonable period of being asked. And of course, what counts as a reasonable period depends on the facts. For example, if your client is the trustee of a multi-million-pound multi-jurisdictional trust, you'll have longer to produce the accounts than if your client was simply the trustee of a one-asset, one-beneficiary trust. Now, in practice, for those bigger trusts, trustees often produce more formal annual reports, but even that won't get around the duty to account. If in the intervening 11 months between accounts, a beneficiary asks for an account, the trustees must at least provide a summary of what's happened since. They can't just say, wait until next April. A third important point to remember here is that the duty to account continues to apply to former trustees and former personal representatives. For example, in the important Henchley and Thompson case, Chief Master Marsh ordered a de facto trustee to provide accounts 20 years after the underlying share portfolio had been liquidated. So that's when the duty is owed, but to whom is the duty owed? Lord Millett summarised it pretty pithily in Armitage and Nurse. Every beneficiary is entitled to see the trust accounts, whether his interest is in possession or not. And the courts have taken this simple and clear idea very seriously. For example, over 50 years ago, the British Columbia Supreme Court held that a clause in a trust deed which restricted the duty to account only to a few beneficiaries was void on the grounds of public policy. Similarly, in England, the English courts have held that trustees must account to beneficiaries who only have a remainder interest, beneficiaries who only have a contingent interest, members of a class of discretionary beneficiaries, and the beneficiaries of the estate of a beneficiary. Now that sounds a bit complicated, but it's actually quite simple. Imagine you're a trustee and I'm a beneficiary. If I die, the beneficiaries of my estate may be able to order you to provide an account. That's how broadly this duty is interpreted. However, there's one very important caveat to everything I've just said. Not every beneficiary is entitled to see everything in the accounts. For example, a beneficiary who only has a future interest in capital will probably not be entitled to see information about the present or past income of the trust. Alternatively, if there are distinct sub-funds within the same trust, a beneficiary is normally only entitled to see the information relating to their sub-fund. And if a beneficiary is only entitled to a specific legacy or a specific bequest in a will, then they are usually only entitled to see information relating to that specific bequest or legacy. Ultimately, though, when deciding what a particular person is entitled to see, you should look at this extract from the RNLI case and the second sentence in particular. What you need to give depends on what is needed in the circumstances for the beneficiaries to appreciate, verify, and if need be, vindicate their own rights against the trustees in respect of the administration of the trust. Now, that obviously varies from case to case, and it can be quite difficult to pin down precisely what somebody is owed. But that's the general principle that you should at least have in mind. So that was our first topic, what the duty actually entails. Let's move on to the second issue, which is what an account should include. Unfortunately, there are relatively few hard and fast rules when it comes to producing accounts. The courts use unhelpfully vague phrases like proper accounts or clear and distinct accounts. Similarly, Form PA1P, which is used to obtain a grant of probate, requires the applicant to confirm that they'll produce full accounts of the estate. These phrases are not particularly insightful, and the reason that they're not particularly insightful is that there's no prescribed form for trusts or estate accounts. It all depends on the facts of the case. As Judge Matthews put it in the second sentence on the slide, an account may be done with formal financial statements or with less formal documents, or indeed none at all. Now, those last 5 words are important, or indeed none at all. In my view, they're too risky to be relied on. Fundamentally, a beneficiary needs to be able to understand if the trustee has managed the trust assets properly. And in my view, a generalized oral description of what they've done is unlikely ever to be enough. Some documentation should be provided. And the reason for this is that the court will test what's been provided against quite a high standard. In the Irish case of Best and Goes, which is cited in Snell's Equity, the court said that the information that's given needs to be sufficient to enable the beneficiary to understand the movements on the account, the nature of the investments, the monies expended and recovered, the income earned, the expenses paid, and how, when, and on what basis investment decisions were made. That's obviously quite involved. And in my view, you're unlikely to be able to convey that accurately and sufficiently simply by having a quick conversation. So those are the basic legal principles. Let's now turn to practical guidance. Now, I'm sure that all of your firms have a precedent trust or estate account in your precedent bank, so it's probably not worth your time me going through the minutiae. But what I thought I'd do is set out some useful sources that you can consider if you want to look up specific issues. The most helpful guide is probably the STEP accounting guidelines, which are available online for about £45. Or if you have access to LexisNexis books, you could look at Division J in either of Tolley's Administration of Estates or Tolley's Administration of Trusts. The 2 sections are not identical. Or if you've got access to Westlaw books, you could consider paragraph D3.3 of the Probate Practice Manual. Ultimately, though, trustees and personal representatives are given a wide discretion over how they produce the relevant information to the beneficiaries. So you don't need to worry too much if your accounts don't look exactly the same as another firm's set of accounts. The final point to bear in mind here, and it's a practical one, is that if you're representing a trustee or personal representative, you can tell them fairly that producing accounts actually helps them. It helps them keep track of assets. It helps them monitor the performance of investments, and it helps them prepare for tax returns. So this shouldn't just be seen as a burden or something that's benefiting the beneficiaries. It is actually good for the trustees or personal representatives as well. So let's now turn to the third and chunkiest part of our talk, litigation relating to accounts. Now, it's a breach of duty not to provide estate accounts when required. Nevertheless, unfortunately, a significant number of complaints from beneficiaries arise because the trustees or personal representatives aren't providing enough information, or they're not answering questions at all, or they're not answering them with sufficient detail. And if that happens, if you're representing a beneficiary and they're not getting the information they want, what can you do? Well, in my view, there are two main remedies and a possible consequential remedy. Firstly, the beneficiary could apply to replace the trustee or personal representative. Alternatively, the beneficiary can apply for an order requiring the trustee or personal representative to provide an account. And in either case, the beneficiary can ask the court to make an adverse costs award against the trustee or personal representative. Now, I don't propose to talk to you about the first of those, removal applications, because I can refer you to my back catalogue of greatest hits. In March of this year, I gave another webinar on the removal of trustees and personal representatives. You'll be able to access it by following the link in the slide or simply going to the Radcliffe Chambers YouTube channel. So instead, what I'll focus on by showing off my PowerPoint skills is the order for an account. And in the final part of this talk, I'll cover 5 sub-issues. Firstly, how you can apply for an order for an account. Secondly, what the court will consider when deciding that application. Thirdly, the terms of an order for an account. Fourthly, the issue of costs. And fifthly, consequential matters. So let's get straight in to how you can apply for an order for an account. There are 3 ways you can do this. Firstly, the beneficiary can apply or issue a Part 8 claim pursuant to Part 64 of the CPR. In practice, this is the most common way of doing it for 2 main reasons. Firstly, most applications for an order for an account can be determined without the court needing to resolve substantial disputes of fact. Often the question is simply, has an account been provided? And usually, if a claim has been issued, the answer is no. Secondly, issuing in the courts means the beneficiary can later apply for consequential orders once the account's been produced. For example, in an estate, your client may want an order for an account and then a consequential order of payment of whatever's due to them according to that account. After all, very few clients simply want to receive a set of accounts at the end of instructing lawyers. The second option is if you think there's likely to be a substantial dispute of fact, or that your client wants to apply for a broader range of remedies, or the dispute's much broader, it may be appropriate to issue the claim by Part 7 of the CPR. In either case, make sure that you list all of the personal representatives or trustees as defendants. And you should also consider joining the other beneficiaries, or if there's too many or they don't want to get involved, you could invite the court to make a representation order. The third option is that in estates disputes, the beneficiaries can issue a summons in the probate district registry, which issued the grant of probate. Now, this type of claim has 2 main advantages over the CPR claims. Firstly, there's no issue fee. And secondly, in some cases, it can be a quicker and more straightforward way of ultimately getting an account from a personal representative. But as I've mentioned, in many cases, your client will want a consequential order, for example, for payment or maybe something else. And it's often more efficient to issue the Part 8 claim rather than go through the summons process and then end up having to make a court claim anyway. Another reason why parties often choose the CPR route is because the court has the power to make both an interim order for an account and an order for an account on a summary judgment application. Both of those can help speed up the process and decrease the gap in time between how long a Part 8 claim takes and how long a summons will take. So those are the powers. That's how you can apply for an order for an account. But what will the court consider when deciding that claim? In general terms, the law is very pro-beneficiary. And the starting point, your first principle, should always be paragraph 60 of Henchley and Thompson. There, Chief Master Marsh says, as you can see, the court has a discretion whether or not to make an order for an account. But, sentence below, although it would not be right to say there's a presumption in favour of making an order for an account, the court will not decline to make an order lightly. In other words, the court leans in favour, in almost all cases, of ordering an account. That's your starting point. That's principle number 1. But there are a few important subsidiary principles as well. Secondly, to secure an order, the beneficiary does not need to prove that the trustee or personal representative has committed a breach of trust in some other way, for example, by taking money from the trust fund. But if the beneficiary wants certain alleged wrongs to be taken into account in particular, then you should plead those or mention them at the very beginning so the court can factor it into the order. For example, if your client is concerned about a particular investment, you could ask the court to make the order directing the trustee to give more information, in particular about that investment, why it was made, when, on whose advice, and so on. A third principle is that it's no excuse that the trustees or personal representatives are inexperienced in producing accounts, because the court will simply say, well, you should instruct an accountant then to help you. Fourthly, similarly, the court will give short shrift to an argument that there are practical or logistical difficulties in producing the account. For example, in the old Freeman and Fairley case, the executor said, I'm stuck in England and all my papers are in India. The court wasn't fazed. It simply extended the period within which he had to produce the account. It wasn't a reason not to make the order. Fifthly, when deciding whether to make an order, the court will take into account what information has already been provided. Naturally, the more information the beneficiary has, the less likely the court will order a full set of accounts to be provided to them. Sixthly, the courts have taken a relatively relaxed approach to limitation in this context. Now, Section 23 of the Limitation Act provides that a claim for an account shall not be brought more than 6 years after the underlying cause of action accrued. However, Henchley and Thompson tells us that if a beneficiary is simply trying to enforce this primary duty to account, that is not an underlying cause of action that has a particular date of accrual. This is simply an ongoing duty that trustees and personal representatives already have. The practical outcome from that is, effectively, there is no limitation period for a pure claim for an account. However, excessive delay is relevant to the court's discretion of whether or not to order an account. And in most cases, a beneficiary will want to have a consequential order as well, often an order for payment. And that type of claim might be subject to a strict limitation period. So in practice, although the claim for an account on its own might have no limitation period, you should work to the limitation period applicable to any consequential claim your client might want to bring. In particular, because the court will consider that when deciding whether to grant the account. But despite all of the clearly very pro-beneficiary principles, the courts have on occasion refused to make an order. For example, the courts have refused to make an order for an account where it would be unnecessary or disproportionate, or if the claimant has no more than a theoretical possibility of benefiting from the trust or the estate. For example, because they're one of a large number of potential beneficiaries in a particular class. Alternatively, the court may refuse to make an order if the beneficiary simply wants to use the account as a way of blackmailing the trustee or personal representative into settling some kind of dispute. On the other hand, trustees and personal representatives can't simply rely on confidentiality. They can't say the information in the accounts is confidential, because the court will simply impose confidentiality undertakings on the beneficiaries, restricting them from disclosing the information to third parties. So really, the situations on the slide are the only real examples of when the court might refuse to order an account. And as you can tell, they're relatively rare. All right, you've managed to persuade a judge to make an order for an account, but what will that order look like? Well, the answer to that question is, of course, it always depends on your particular case, not least because the court has a wide discretion over what it can require the trustees or personal representatives to do when they produce that account. For example, the court may give directions as to the manner in which the account's to be taken, or the inquiry that's to be conducted. Similarly, paragraph 23.2 of the Chancery Guide suggests that, at least in the High Court, judges will often include directions relating to who needs to file the account and when, and what period the beneficiaries have for challenging that account, and then how long and when the beneficiary should be given to inspect the underlying documents. But if the order isn't clear enough, or if something unexpected comes up, any party can apply to the court for further directions on the accounting process. Practically, in my view, if you're coming on behalf of a trustee or personal representative to court and asking for an order. If they're not sophisticated, it can often be helpful to spell out exactly what is required in the account. Don't simply say, provide an account within 28 days. Set out, for example, list of assets, both at the time of death and now, list of expenses incurred in the last year, and when, and so forth, just so there's absolutely no uncertainty over what's required. Because the last thing your client wants is to have to come back to court, either as a beneficiary or a trustee, and go through the process again, because the first set of accounts didn't cover everything. Obviously, costs are always very important in litigation, and in accounting cases, the rules are pretty pro-beneficiary. But technically, the starting point is the same as always. There is no automatic entitlement to a costs award for the beneficiaries. However, the courts will normally make an adverse costs award against the trustee or personal representative if they've persistently failed to provide the appropriate information. And in fact, if the failure is particularly serious, the court may also require the trustee to pay the costs of the accounting process and may even deny them their indemnity. On the other hand, though, if the beneficiary issues a claim unnecessarily early, for example, without giving the trustee time to respond to pre-action requests, then the court may make a costs award against the beneficiary. It doesn't happen often, but it is possible. So as always, if you're acting for a beneficiary, even with the law kind of stacked in your favour, don't be too aggressive in starting litigation. The final topic are consequential matters, which is what happens once you've got your order. One of the main advantages of getting an order for an account is that it can be enforced by committal proceedings if the trustee or personal representative doesn't comply. So this provides a powerful incentive for them to do what your client wants. But even if you do get the information, even if you do get an account, don't forget, the account is rarely an end in and of itself. As Lord Millett put it in the Hall case, an account is merely the first step in a process which enables the beneficiary to identify and quantify any deficit in the trust fund and seek the appropriate means by which it may be made good. So in practice, once your client receives the account, they should look through it very carefully to see if there's anything they want to challenge. And if there is anything amiss, they should immediately write to the trustee or personal representative and ask for an explanation. And this is where we come across the words surcharging and falsifying. Now, they may sound complicated, but they're actually quite simple. If a beneficiary says the trustee should have done something more, for example, they should have got more interest on an investment, they can ask the court to surcharge or simply add more to the bottom line of the account. On the other hand, if the beneficiary says the trustee spent money they shouldn't have done, for example, on unnecessary expenses, they can ask the court to falsify the account. In other words, delete certain entries and again, increase the bottom line. And in either situation, the trustee must personally pay the difference between the bottom line in the account and the amended figure. Alternatively to all of this, beneficiaries can exercise the power in Section 13 of the Public Trustee Act to require the trustees to have the accounts audited by a solicitor or accountant agreed by the parties, or if they can't agree, the public trustee. Now, I've tucked this away right at the end because this power is in practice rarely used. The main reason is that the public trustee can make a costs order at the end of the process. And if they feel that the beneficiary's request for an audit was unnecessary, the beneficiary can be penalised. So I put it there because it's technically possible, but it's rarely used in practice. That, hopefully, is a good account of trust accounts. But for now, folks, it's what you've been waiting for. It's our headline act. It's Jonathan Edwards.
Right, well, as I mentioned earlier, I'm going to be speaking about claims under the 1975 Act, full name of which, Inheritance Provision for Family Independence Act, 1975. I'm going to cover a range of topics. Talk's going to be a mix of quickly running through the basic principles, which I imagine most, if not all of you, will already know. I'll make a few remarks on those. I'm going to dwell more on some points which I think are more recent developments and that I think might not be as widely appreciated as they ought to be. Okay, so the first basic question is who can bring a claim? And there's a list of categories of people. You have to be in one of them. You can't, there's not really any flexibility there's no residual category. The first category is people who were spouses or civil partners and still were at the time of death. Interesting point about this is tucked away near the back of the Act is provision that it can actually include people who were not validly married or in a civil partnership. Because if the claimant entered into an apparent marriage or civil partnership in good faith, they come within the definition. That happens more often than you might think, because the situations where I've encountered it are where parties previously lived abroad, or one of them did, and had a marriage in a different jurisdiction. So the registration process didn't work as it was intended, and they managed to go through a new marriage ceremony in this jurisdiction without their previous marriage having been dissolved. So that's the kind of situation where that arises. It does happen more often than you might expect. Second category are people who used to be married or in a civil partnership with the deceased, but ceased to be. I don't see very many of these claims, in fact, I don't think I've actually seen any. And there don't seem to be many reported either. It's limited to people who have not subsequently married or entered into a new civil partnership. And I think the reason why you see so few of them is that most of the time when a marriage and civil partnership has come to an end and there are assets to divide up, the parties do something about it. And one of the powers that court can exercise in that situation is they can bar any future claim under this Act. So those don't come up very often. An important category, and one of the more difficult ones, are people cohabiting with the deceased. And that requires 2 years of living in the same household as the deceased, as if they were married or civil partners. And it does have to be the 2 years up until death. The thing with this category is because, unlike marriage, where it's usually pretty clear whether you're married or you're not, this one is much more fuzzy around the edges. And a few different questions can arise: whether the nature of the relationship qualifies, there's some case law on that. And there's an interesting question of whether it's possible for the deceased to have had 2 separate households simultaneously. That's not been decisively resolved. That comes up in basically 2 ways. One is where deceased had previously been married and remained married, even though the relationship with their spouse in practical terms came to an end, as sometimes called a fossil marriage. And then they cohabit with someone else, and they might be functionally to all the world as if they'd been remarried to this new person, but in fact they never were. In the case of fossil marriages, it's found that cohabitants can bring a claim, even though the deceased was also married. The other situation is where, pretty rare, but it can happen, is where the deceased is actually maintaining 2 separate relationships at the same time, conceivably without the individuals knowing of each other. And although it's not been decisively resolved, I think in a case where someone actually is leading 2 separate lives with perhaps 2 separate families, I think it must be possible for both of the cohabitants to claim. An increasingly popular category of claimant is children, which includes adult children. Tend not to see that many cases about minor children. I think that's probably because most people do make provision for their minor children in their wills, and probably also because everyone would recognise that minor children who are necessarily dependent are going to have especially strong claims for some provision. So they're less likely to go to trial, I imagine. But adult children is an increasingly contentious and popular category of claimant after the famous case of Eilert, which went all the way up to the Supreme Court. Another category related one is child of the family. This is where someone is not a biological child of the deceased, but they were treated by the deceased as a child of a family where the deceased was in the role of a parent. The most obvious person who's likely to be in this category is a stepchild, particularly a minor stepchild or a child from a partner's previous relationship who has come to live with the family. But there are other possible situations as well. And then finally, this category This doesn't overlap with any of the others. I quite often see people claim to come into one of the other categories and also this, but strictly speaking, this category is other people who don't come into one of the other categories, but they're nonetheless maintained by the deceased. The maintenance has to be substantial, so the occasional birthday present isn't likely to qualify, and it does not include contributions made for full valuable consideration pursuant to an arrangement of a commercial nature. So for example, a live-in carer is unlikely to qualify because they're probably going to be excluded by that exception. Anecdotally, I've heard of an interesting case about a deceased party who had a sort of recurring or on and off relationship with a male escort. And the question was whether that was a relationship of a commercial nature or not. Unclear. So there can be some borderline cases. Another short point on eligibility to claim. The claimant has to be alive. One might not thought this is surprising, but it has been tested in the case law. It's not possible to say, I'm a personal representative, a person who could have claimed and perhaps should have claimed, but didn't. I now want to bring the claim for the benefit of their estate. That can't work. It's been tried and it didn't work. Related point is, even if you've already brought the claim, if the claimant then dies, the claim dies with them. That leaves the question of what happens to the costs if the claim has already been commenced, because you might have racked up quite a lot of costs, because you might have got all the way to trial even before this happens to intervene. I haven't found any particularly clear answer to that question, but I think there's probably quite a lot of force in saying that the costs lie where they fall, because there's not been any determination of the merits of the claim. And quite often, you imagine the court would be of view, it'd be disproportionate to try the claim on a hypothetical basis, just for the question of working out costs. But that's not entirely clear to me what the approach of the courts will be in that situation. It does mean that theoretically, with an elderly or very ill claimant, the defendants could adopt the tactic of trying to outweight them and hope, if we can put it that way, that the claimant will die. I don't think you'll find many clients who admit that that's going to be their strategy, and it's probably not a good one because people can live a lot longer than you would expect. But it's worth bearing in mind, particularly worth bearing in mind, I would suggest, if you're contemplating entering into a CFA with a very elderly or very ill claimant. Question which frequently occurs is the question of the time limit for claiming. Occurs so frequently because it's quite a short period. A lot of people don't really know about this act, and because of the very nature of it, the people who are in a position to make a good claim often don't have much in the way of financial resources, so it might not readily resort to getting legal advice. The time limit runs from the first grant of representation, and it's only 6 months. Of course, what that means in practice depends entirely on how long it takes for the grant to be obtained. And that leads to a common tactic, which is for a person contemplating a claim, entering a caveat against the estate to make it more difficult to obtain a grant, even though they've got no grounds for challenging the will itself as a valid will. That's a very common tactic. In my view, it's best avoided because what it exposes you to is the risk of the beneficiaries of the estate applying to the court for the removal of the caveat on the basis that there's no possible ground for the caveat, and then you can start off with an adverse costs order. And so in my view, best not to do that. If you're going to bring the claim you want to buy time, I think you need to find a different way about it. One option is a standstill agreement, although I've got to be cautious about relying on those. The other option is to actually issue the claim and then seek a stay for any further negotiations. The reason people are so reluctant to do that is because it has to be a Part 8 claim. You have to have your evidence and support ready to go pretty much straight away. The way that people tend to get around that or avoid the problem that causes is to produce a very short witness statement dealing with the claim only in very brief outline and saying that they will seek opportunity to produce further evidence down the line. Technically, there's a degree of risk in that because the court could say no further evidence. In practice, however, the courts I find are quite amenable to this approach, provided that the initial witness statement, even if it's brief, it does have to, in outline, address the relevant requirements. But that's not actually very difficult to do. It's the requirements, the factors that are relevant. There are several of them, but they're not particularly complicated to analyze. So you can usually say something about them pretty much straight away. And I think that's the best tactic. Get on with issuing the claim, shows the other side that you're serious about the claim, for one thing. And it means you don't have to worry about the time limit anymore. The other option, as I mentioned, is standstill agreement. Technically, these don't work. Even if you have a standstill agreement, you still need the permission of the court, and the court isn't bound by a standstill agreement. And there was the case of Cowan and Foreman, which created a great deal of uproar because the first instance judge was very deprecating about standstill agreements. Court of Appeal less so. And in my view, if you've entered into a standstill agreement before the expiry of the 6-month period, and then you bring the claim within the time provided for by a standstill agreement, you are extremely likely in practice to get permission to bring it technically out of time, because the other side know about the claim, so they're not taken by surprise by the lateness of it. And by entering into the standstill agreement, they've in effect acquiesced with the approach you're taking. Slightly sting in the tail, make sure your standstill agreement is with all the relevant parties, because you might find you've got a standstill agreement with one of the beneficiaries, then the other beneficiary says, well, I was never a party to that, I wouldn't have agreed, so it's not affected by me, I want to rely on the time limit having expired. However, even where proper precautions haven't been taken and the claim is sought to be brought out of time, I find that the courts do quite often grant the permission. There are a number of factors to be taken into account. There's quite a bit of case law on this. The factors are summarised in Cowan and Foreman, and in the other case there, Thakari and Busate, which you'll need to consider in a particular case. But I tend to find the courts are quite receptive to these applications, and you are taking a risk if you try and head off the claim by saying, no, we resist the application to bring it out of time. So it's one to weigh up quite carefully, because if you resist it and you cause there to be a lengthy hearing just about that and you lose, you might well have to pay the costs of that regardless of the ultimate outcome. So it is risky, particularly because there's not any period of time where you can be pretty confident that after that your resistance will succeed. And the Busate case is a particularly notable example because it was an extremely long period of time, more than a quarter of a century after the expiry of the time limit, and permission was still given. Of course, that depends on the particular facts, but it does mean you can never be entirely sure that it's too late to bring the claim. So that's worth bearing in mind from both sides. In terms of what can be claimed, the main point to be aware of, as I expect most people know, is that there are two different tests. Bereaved spouses and civil partners are treated differently. It's such financial provision as would be reasonable for them to receive, and it's not limited to maintenance. Everyone else, it's again reasonable financial provision, but it is limited to maintenance. Maintenance is quite a broad concept, but you do have to connect it at the end of the day with meeting ordinary expenses of living. That can be done directly or indirectly. So for example, providing a capital sum might enable the purchase of accommodation, which then means you're not paying rent for rented accommodation. So that indirectly does meet everyday expenses. And in practice, seeking a capital sum for accommodation is one of the most popular and well recognized kinds of claim one can make. But it is important to bear in mind that it does have to come back to meeting expenses. It's not a question of what would be reasonable just in general terms, what would it be nice to have? In terms of actually framing the award, the court has extremely broad powers to do it. It can do all sorts of things. It can certainly override anything in the will, including, interestingly, no contest provisions. People sometimes include in their will a provision that if anyone brings a claim under this act, then what the will does give them will be taken away as a way of trying to deter claims. However, if a claim is brought, the court can override that. Say, well, there may be this no contest provision, but excising the statutory jurisdiction, reasonable financial provision still needs to be made. And the court's powers do enable quite elaborate arrangements to be constructed. So, for instance, it's not unknown for the court to provide a capital sum, but provide it on a life interest basis with the idea that the value will revert to the estate after the death of the claimant, but then add in some extra provisos. For example, enabling capital to be advanced to the claimant permanently in certain eventualities, for instance, if they need it for care home fees. So the court can do quite elaborate arrangements under the Act, although I tend to find simplicity is attractive. Last point of interest in terms of what can be claimed is it doesn't actually have to be a net financial benefit to you. There was the interesting, relatively recent case of Lewis and Warner, where the claimant wasn't seeking to be given money or assets, but was interested in obtaining the specific property. And in the circumstances of that case, because it won't be every case, it was held that it was appropriate under the Act. The Act did enable an award which would allow the transfer of that specific property to the claimant, but at full value. So the claimant wasn't getting anything financially, but they did get what they wanted. It's obviously quite an unusual case. But it really emphasizes the flexibility of the court's remedies. Also worth bearing in mind some of the other provisions under the Act which can come into play. First one, possibly underappreciated, is that the court can make an interim order for provision where the claimant's got immediate pressing needs, which is not infrequently, and there are assets available for meeting that need. The main reason not to do this, I think, is because it creates an additional argument. You might need to have a hearing just about this, so it can increase costs. But I think consideration should be given to it more often than it seems to be. Because very often it's the immediate cash flow position that is of a great concern to the claimant. One of the things is joint tenancy. The Act can look past that, essentially. If the property is passed by survivorship and therefore technically isn't within the estate, the court can treat it as being in the estate. It's not automatic, but the court can do it. And then Section 10 is an anti-avoidance provision. Doesn't seem to come up that often. I think I've only advised on it once. That you can look back a certain number of years and transactions that were intended to shield assets from claimants under the Act can be got at this way and can be got out of the hands of third parties even. You do need to show the intention to defeat claims for financial provision. There's not much authority at all on what exactly that requires. But I think the better view is that you don't need to show the deceased actually had the possibility of a claim under the 1975 Act in mind when seeking to avoid transaction. And there is a county court decision which is suggested to support that view, but is not authoritative. My own view is that the situation that you might encounter is where the deceased wasn't expecting to die, wasn't expecting to face a 1975 Act claim, but was anticipating divorce. And I think that might well be sufficient. If they were trying to shield their assets from the claimant making a divorce claim, then I personally am of the view that that is sufficient also for this provision, because it's the same intent in substance, even though the legal claim that the deceased is worried about is different. But I don't think that's absolutely established. But at minimum, I think that must be the case where the deceased can foresee the possibility that they might die before the claim is brought, that they're trying to shield against, which might be the case if they're diagnosed with cancer, for instance. I'm not going to dwell too much on the relevant factors because these are very fact sensitive. There's no alternative, but in each case you're dealing with to go through them methodically. One point it's important to be aware of is that you're always bearing in mind what the information is going to be at the time of the hearing, which means merits of the case can change quite a lot between even the issue of the claim and it reaching trial. So you always need to keep on top of any developments. It also means that practical terms, when you're preparing your directions, that you want to make provision for the evidence to be updated so that the court's got current information, especially about values of any assets, because property prices might change, and about the needs and resources of the claimant, which might have improved or deteriorated over time. But yes, the merits of the claim can change over time. And perhaps that's especially important with teenage claimants, because it's quite easily possible that a minor child during the litigation process, or certainly after the death of the deceased, but before the claim is determined, which could be 2 or 3 years later, their circumstances might change quite radically. Having previously been at school, they might no longer be in full-time education, for instance. So one has to be especially aware of this point for people like that. The situation is rapidly changing. Moving on to the factors themselves, I always take this one out of order because it seems to me to be of special importance. It's the size and nature of the net estate, because that's what the court's dealing with. You're seeking provision from the estate. And it's really impossible to compare outcomes between different cases where you've got estates of very different values. The approach is extremely different in big money cases, ordinary cases, and estates of extremely modest values. So I always think that's the first thing to bear in mind. It's important not to be led astray by, for instance, the very lavish awards that can be made in cases where the estate is multiple millions of pounds. That's not a good guide to your case if the estate is essentially just the deceased property worth £500,000. The meat of the case is going to be the financial resources and needs of the relevant parties. That's the claimant, any other claimants under the Act, and the beneficiaries of the estate. And that's their financial resources and needs at the time, but also any that can be foreseen as likely. So care home fees often comes up with relatively elderly parties. And it does include financial obligations and responsibilities as well, such as debts. Then there are a few other factors, obligations and responsibilities of the deceased. I regard this as inviting the court to examine the character of the relationship. To what extent did the deceased assume responsibility for the person's well-being? Physical or mental disabilities, the significance of that is obvious. Such disabilities can create additional needs and can also impact on their likely financial resources, particularly the ability to earn money. And lastly, there is a catch-all category of any other matter the court considers relevant, which many parties see as an invitation to dig up all sorts of historic grievances. It's generally discouraged, but technically the court can take it into account. So if you've got something that seems on the facts of the case really important, you can get it in under this heading. Also important to be aware that as well as those factors which apply generally, there are some special factors which apply to particular categories of claimant. These are all, I think, fairly straightforward. The most complicated one, or most significant, is that where the claimant was married to the deceased or in a civil partnership, there is a cross-check with what might have happened, what might reasonably be expected to have happened, if instead of the deceased dying, they'd got divorced on that date. The court is required to have regard to that outcome, but it's not a cap and it's not a floor either. it is just a cross-check to have regard to. And the most important difference, of course, is that in divorce, both the parties to the marriage or civil partnership are still alive. They both have needs themselves, whereas the claim under the 1975 Act, by its very nature, that is not the case. So where resources are not so extravagant that they can be all needs and then some. So in a needs-focused case where you're trying to stretch resources to meet parties' needs, that is going to be easier if only one of the parties' needs remains relevant, because only one of them is still alive. So that's something to be very wary of when applying the cross-check. If the case is all about needs, the cross-check might underestimate the strength of the claim. The other factors, I think, are more straightforward. For cohabiting parties, the length of the cohabitation is obviously extremely important. So it's the age of the claimant. So there's any contribution to the welfare of the family. Because if someone has been, although not married, in the role of parent, that's going to demonstrate that the relationship is of great substance, and that the nature of that relationship has to be factored in when deciding what would be reasonable for them to receive. Children, the extent of maintenance in the past has to be taken into account, and same with any other parties who are maintained by the deceased. Some comments on strategy. On the claimant side, I think it's particularly important and underestimated to really think about what you're asking for, because the temptation is to keep this as broad as possible so you don't undersell it. But I think it's important to try and pitch it at an optimistic end, but still within a realistic range, because that will assist with negotiations. It will assist with presenting the case at trial, because you're presenting the court with something it might actually do, rather than something wildly extravagant. And it's also helpful with managing the client's expectations, because if they've started off the claim seeking enormous awards, can be difficult to persuade them that actually they need to accept a lot less. Clarity that goes to both is it's very desirable to make settlement offers, because these claims can be very difficult to judge, particularly because the quantification can vary over time and different judges can take different views of it. On the defendant's side, one of the major questions is to decide whether or not you're going to ask the court to consider the beneficiary's own financial position. You're going to say these are needy beneficiaries whose benefits under the will or intestacy should not be eroded. People are very tempted to do this because it gives you another way of attacking the claim. But I would suggest there are a few reasons to at least consider not doing it. One is privacy, because if you ask the court to take into account your financial position, you're going to have to give some disclosure about it and face cross-examination. Second is expense. Adding these issues into the case is going to cost more money. And the third, there can be a presentational risk, because you might end up trying to be as stingy as possible with the claimant's claimed needs, while at the same time taking a complete opposite approach with one's own needs. And I think that risks coming across as unreasonable, which is not going to be helpful at trial. The other major consideration is whether to bring in conduct points. Usually the answer is no. You have to really feel that on the facts of the case, it's a really powerful reason why the claimant didn't receive more in the first place. Otherwise, you're just taking up more time and spending more money on issues that probably aren't going to sway the court anyway. Funding is very important. The usual cost rules do apply. Question of cash flow are important and can be dealt with in a couple of ways. If you're a defendant's side, you might try and get an interim distribution from the estate. That's particularly viable where it's clear that the claim is going to leave a lot of the estate untouched, because then an interim distribution can be made relatively safely. If you're the claimant, one tactic do see, and I suspect will become more popular, is asking for an interim order for the purpose of freeing up money to fight the claim. I have seen cases where people have overtly stated that that's the purpose of part of the amount they're seeking by way of interim order. Interesting recent issue where we're still awaiting decision of the Court of Appeal. And in fact, this was Sophia Rogers' case. I can speak more freely about it than perhaps she can. The judgment is still awaited. The question is about whether the liability to pay an uplift should be taken into account when working out what award to make. And the main argument is because it's not possible now to get the uplift through a costs order. So if it's not being met through a costs order and the claimant still has to pay it, if the court's decided that they need £100,000 for their needs, but then the uplift comes out of that, then necessarily they're getting less than what the court thought was appropriate. And so that's the argument that the court should be able to take it into account and effectively award more so that the uplift or some of it is covered. And counter argument is that this is inappropriate. It's allowing something you can't get by costs at all. You're getting it by the back door this way. And it also interferes with judging offers. And I thought I'd do a quick poll on this question about, I imagine many people practicing this area will have views on this. So I was interested to test what people thought. Hopefully you can see that poll. I'll just leave you a couple of minutes. See, okay, that's interesting. Numbers have settled down a bit. It's about 70%, 30% in favour of allowing the uplifts to be taken into account, which is what the judge decided at first instance. In other cases, judges have gone the other way, or at least one. But we'll see what the Court of Appeal makes of it. Share those results quickly. To wrap up, ADR settlement is really important in these kind of cases because they are not cut and dried most of the time, and they can be very expensive to litigate. Well-known points to take into account are tax considerations, because even a consent order will have retrospective effect. Nature of the case very often means you have minor parties, so they might need court approval. So any settlement has to be acceptable to the court, taking into account the interests of the minors. A point that I think is overlooked is you need to be careful with framing the offer, because particularly with Part 36 offers, one of the major purposes of them is to be able at the end of trial to compare the outcome with the offer and say you've beaten it. It needs therefore to be easily comparable with something the court might actually do, which to my mind favours offers that are simple. You can make a non-Part 36 offer, that's complicated as you like, but if you're trying to get the protection of Part 36, I think it's desirable to have a simple offer. You also need to bear in mind that if you win under the 75 Act, the award is treated as effectively a legacy and has to be enforced not as a money judgment, if it's money, but in the same way as any claim under a will. And therefore, I think it's important to frame the offer that way, because otherwise, if you're a claimant, you might make an offer and look like you've beaten it, but the defendant can say, well, really, that's not the case, because to accept this offer would have required me to pay over a load of money, which I don't have. It's in the estate, and the offer didn't take that into account. So that's a way to inadvertently lose the advantages of Part 36. So that requires particular care, and I think that is often overlooked. Lastly, the court can direct that there be early neutral evaluation without the consent of the parties. Fairly recent case deciding that point. Personally, I'm skeptical about whether that's a good idea if both parties don't want it. But perhaps where there's a party that's unwilling to face up to reality, this is a useful technique to get them to hear it from the judge that their position is not realistic. Although I've always thought it's a bit of a shame if you go to an early neutral evaluation, you get a favourable view from the judge for your side, but then that judge can't hear the trial. Hopefully a different judge will take a similar view, although there's no guarantee. Lastly, There's been talk recently about whether mediation will be made compulsory in any cases in civil litigation. If that does happen, I think 1975 Act claim is going to be a prime candidate for that treatment. Right, that's all from me. One question is whether the claimant has 6 months to issue and a further 4 months to serve. Should executors wait 10 months for distributing? The answer to this is probably yes, as a counsel of caution. If you think a claim might well be in the offing. On the other hand, I don't think the risk is great. I think after the 6 months has expired, if you've not heard anything, if you've not been told a claim is in the works, I think it's extremely unlikely anyone would criticise executors for distributing the estate in those circumstances. And really, the claimant would only have themselves to blame for not making clear that the claim is in the works. One question is, if you believe that deceased may have moved money out of the estate, how do you deal with this before proceedings if you feel the information could be withheld? Would you ask for details of all financial assets and letter of claim? And make clear that these should include assets that do not pass by will. Yes, I think if you're concerned about this, it's a good idea to raise it at the earliest possible juncture, particularly because what you might need to be doing in the end is getting the assets out of the hands of third parties. I think the way I'd be inclined to do this is if you have these suspicions, you probably have some idea of assets that the deceased had at a point in time in the past, and you're worried about what's happened to those assets. So in that case, I would identify those assets as far as possible in your letter, ask for information about what assets the deceased had at that time, and ask for what happened to them. And if the other side object to this, saying it's not relevant, you can, of course, point out that there is the ability to unravel transactions under Section 10. So the answer to the question is yes, I would ask for detail. And you're going to want to use the information you do have to try and be as specific as possible. That's the only real way you're going to be able to deal with concerns about non-disclosure. Where a claimant dies during the claim, but before it's determined, is there any need to formally withdraw the claim? I think not. I think the claim ends as it is. I don't see how any particular formality would be required. You'll obviously want to notify people. The court needs to know, particularly if there's a trial listed. But I don't think any formal step is actually requested because, to my mind, it's difficult to see why that would be needed or what anyone can do about it if you don't take that step, because the claim is still ended, can't be continued with. I suppose if the other side want to say, well, what about our costs? I think probably the onus is on them to take proactive steps about it. Haley suggests the outcome on re-H may have been different if it hadn't been in the family division, where they used to factor in costs in an award. I do agree with this. I think one of the arguments in the case is that an analogy should be drawn with divorce cases, where routinely the litigation costs are out in the open and are factored in. So I do think it's something where different parts of the court system might approach it differently. And in fact, the case I mentioned where the judge went a different way, it's a case called Re Clark, which was in the Chancery Division. So I do agree that can make a difference. Hopefully the Court of Appeal will decide the point in a way that can then be followed across the board consistently. Question, couple have been living as if married for over 2 years. The question is, person A owns a property entirely for which second person pays monthly rent. Does that commercial relationship affect any claims? I don't think that prevents the person bringing a claim as a cohabitant. If you in the category of cohabitant, then the fact there might be a commercial relationship as well doesn't disqualify you. It will need to be taken into account because these are very fact-sensitive claims, and the fact that someone has been paying monthly rent to live in the property makes it more difficult to say that what's reasonable financial provision now is to be able to live in the property for free because they're getting something they didn't used to have. So I think it is relevant and does factor into a claim under the Act, but it doesn't prevent the claim in any way.
There are two questions for me. One's from Rose, and she says, what should an executor do if an unreasonable beneficiary won't sign estate accounts, and says she will oppose any costs of a court application coming out of the estate? Now, as far as I'm aware, there's no strict legal requirement for beneficiaries to approve final estate accounts, but it's obviously a very, very good idea in practice because it can limit future challenges. Now, from the brief question I was given, it's quite difficult to know what this beneficiary actually wants. They don't want to approve the accounts and they don't want a court claim, but what do they want? So in practice, if you don't know, the first thing you should do is write to the beneficiary solicitors and say, what is it that the client is concerned with? Is it a particular expense? Is it a particular legacy? Are they challenging the entire administration? You need to narrow down what her concern is. Ultimately, if you can't reach agreement though, then it probably will be necessary to go and get directions from the court. But before that, to try and sort of bolster your client's case and make the beneficiary realize her position, you should emphasize, firstly, you should explain very clearly what your client's been doing, so any concerns the beneficiary have can be answered in open correspondence. Secondly, you should invite alternative methods of resolving this dispute from the beneficiary, again, to show you're willing to do this out of court. Thirdly, you can remind the beneficiary of a brilliantly named case called Muscles and Patience from 2018, where Judge Matthews emphasized that it's actually quite difficult for a beneficiary to challenge estate expenses. Now, commonly the challenges are brought to solicitors' fees for those advising the estate, but that was dealt with in that case as well. So that's quite a helpful one that you can put into any correspondence. And the final point is about costs. You can remind the beneficiary of the general rule that trustees are allowed their costs out of the trust fund, and that in accordance with paragraph 1.1 of Practice Direction 46, it's not that easy to get around that general rule. So you can fairly say to the beneficiary, look, unless you particularize your case, we'll have to go and get directions and we'll probably win and we'll probably get our costs. So hopefully that should encourage the beneficiary to explain herself and be more reasonable with any particular issues she's concerned with. The second question for me is from Anonymous, and it says, would you ever make application for removal and an application for an account at the same time? This person has in mind the best way to deal with executors who you want to remove, but fear may have taken money from the estate or refuse to hand over records. Now, in practice, in my view, you're unlikely to want to apply for both removal and an account off the bat. After all, if you think that the person shouldn't be in office and can't do a good job, why would you trust the account that they produce just before they leave? Also, practically, the threshold for an account is lower. It's much easier to get one of those than it is to remove someone. So if all you're concerned about is an account, don't overcomplicate it with the more confrontational removal application. Just ask for the account. But if you want to do the removal application, put both feet into that. The reason I mentioned removal is it's a possible consequence. If once your client receives the accounts, they realize for the first time something dodgy's been going on, or it brings home the fact that the trustee or PR is just hopelessly out of their depth because they can't even produce coherent accounts. In those situations, what comes out of the account might give your client cause to want to remove them. And that's why I cited the decision of Mr. Justice Briggs, as he then was, as an example. But in this particular person's case, it seems that the concern is about handing over assets on a change of trustee or PR. And that's probably most easily dealt with in the removal application if it's brought. But in the meantime, obviously, you can remind the PR's lawyers of the rules, the obligations to transfer assets on change of PR and the court's powers to make essentially vesting orders for someone who's not complying. So that's how I would approach that problem. I don't think there are any further questions from me. I don't think there's any further questions from Jonathan. We've already gone over thanks to all of your brilliant engagement. So thank you very, very much for spending time with us on this Thursday morning. It's been lovely to have you. Welcome back to the new junior program. There'll be more coming up in the next few months. And until the next time, have a lovely day and thank you very much. Goodbye.